think, and most significantly, take action. Heedless, then stealthy, then brazen. How the government defeated the Fourth Amendment. That's our topic today. Mr. Balko, the floor is yours.
Thank you. Thank you to SFL for inviting me to speak. I spoke at the very first one of these events when, I don't know, maybe people in the first 2 rows were probably the entire population in attendance, so it's been great to watch you guys grow over the years, and I'm honored to be here. So my talk today is about the Fourth Amendment, sort of what's happened to the Fourth Amendment over the years. It's going to require a little bit of history, but I'll try to get us caught up as quickly as possible. Back in 1995, shortly after the Republicans had taken over Congress, part of their contract with America was an assault on the exclusionary rules, the rule that says that the police violate your Fourth Amendment rights during a search. The evidence that they collect after doing so cannot be used against you at trial. Exclusionary rule has long been a target of the political right, and the Gingrich-led Republicans had introduced a bill to severely erode the exclusionary rule and attack a lot of the court rulings upholding it. Alarmed, Representative Mel Watt from North Carolina introduced an amendment to the bill. I'm going to read you the amendment to the bill that he added. The amendment reads this: the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. This, of course, was the Fourth Amendment that Congressman Watt had attached to this bill that was, in effect, an attack on the Fourth Amendment. The amendment, being the Fourth Amendment, was put to a vote and defeated in the U.S. House of Representatives by a 3-to-1 margin. This is not particularly surprising. Over the years, a number of public opinion polls have shown that when they're not told that it's actually the Fourth Amendment they're being asked about, most Americans overwhelmingly disapprove of the Fourth Amendment. In 1969, 60 Minutes did an entire segment based on polls they conducted with the American public, asking them whether they supported various provisions of the Bill of Rights, not telling them that they were from the Bill of Rights, and every single Bill of Rights amendment was defeated or was opposed by a majority of the respondents to the poll. Back in the 1980s, we were sort of at the height of drug war hysteria. There were also a number of other polls. In 1999, the Washington Post and ABC News found that 62% of Americans said that they would be willing to give up many of their freedoms if it meant we could greatly reduce the amount of illegal drug use. Another 52% agreed that police should be able to search without a court order, without a warrant, the houses of people suspected of selling drugs, even if the houses of people like you are sometimes searched by mistake. Another poll showed 70% of people supporting warrantless, random drug raids on public housing tenants. This is a policy later adopted by the Clinton administration. So it shouldn't be really of much surprise that our politicians and courts have attacked the Fourth Amendment over the last generation in particular, and particularly through the course of the drug war, when most of the public has a difficult time supporting the Fourth Amendment as well. So let me give you a quick sort of history of how we got the Fourth Amendment. A lot of you probably know this, but it's important to sort of set up the story. So we have the Fourth Amendment because during the years leading up to the American Revolution, the British had passed a series of tax and import laws. In order to enforce those laws, Britain stationed soldiers in the streets of a number of American cities, pre-American cities, particularly in Boston, where there was a kind of a hub of revolutionary fervor going on. The British soldiers were armed with what they call writs of assistance. These were general warrants that were basically open-ended. But the warrants didn't expire until a year after the death of the king who was in power when the warrant was issued. And the person who was given the warrant was given wide latitude. There was no specificity to a house or residence. There was no specificity to a suspect. Basically, if you were given one of these writs of assistance to enforce, say, a particular import law, you had authority to basically search any house at any time. And in fact, the name writs of assistance meant you could also basically conscript local colonists to help you in your searches, whether they wanted to or not. This, as you might guess, caused some consternation among the colonists, led to a number of revolts, some violent revolts, And it was really kind of this memory of these general open warrants that gave us the Fourth Amendment, which requires specific information about the residence to be searched, the person to research, that's going to be searched, and requires, the way it's been interpreted since, the authorities to show some sort of probable cause. They can't just break into your house based on nothing but suspicions. Interestingly, the writs of assistance, the various sort of tactics that inspired the Revolutionary War that gave us the Fourth Amendment were in some ways less restrictive than warrants, or excuse me, more restrictive than warrants are today. For example, writs of assistance could not be served at night. And writs of assistance required the British soldiers to knock, announce themselves, and wait a reasonable time for somebody inside to come and answer the door before they were allowed to force entry into the residence. And this, of course, is not the case anymore today, which I'll get into in a minute. So this is why we have the Fourth Amendment. It's this idea that the government should not be able to break into your house, it should not be able to search a person based merely on a hunch, right? The hunch of some sort of law enforcement official or government agent. So how's the Fourth Amendment enforced? Well, there are a few ways that we enforce it. The first is the aforementioned exclusionary rule. And this has really become the most effective way to enforce it, mostly by default. But basically, the way this works is that the theory is that police will be deterred from violating your Fourth Amendment rights if any evidence they collect as a result of violating those rights can't be used against you at trial. The idea is it would be a huge waste of their time, and it's actually been fairly effective in this way. The second way we can enforce the Fourth Amendment is through civil lawsuits. Right? So if your rights are violated by an illegal search, you can sue the police officers and the government entity in question for that violation of your rights. This too has been severely limited by qualified immunity that's given to police officers and the sovereign immunity that's given to government entities. Internal discipline is another theoretical way that the Fourth Amendment can be enforced, and this is the idea that police agencies themselves will impose professional sanction on police officers who violate your Fourth Amendment rights. This too has not been particularly effective. And the final way is for political pressure, and is that sheriffs are elected, mayors who appoint police chiefs are elected, and the idea is that if police are routinely violating the civil rights of citizens, the population will sort of rise up and demand new political leadership, and that too has been particularly ineffective. So the exclusionary rule is sort of the primary way that the Fourth Amendment has been enforced, and it's really been the only way it's been enforced because the other ways we can enforce it have largely been ineffective. So that out of the way, I want to talk about sort of the various ways that the Fourth Amendment has been erased over the years. We'll start with the Castle Doctrine. The Castle Doctrine is this age-old idea that the home should be a place of peace and sanctuary. Right? It should be a place where you can sort of gather with your family and be unafraid of people, doing you harm, breaking in, whether it's a criminal or whether it's an agent of the government. Going back to centuries of British common law, the Castle Doctrine has always been enforced through what's known as the knock and announce rule. This is the rule that says that if the government comes and they want to come into your house, they have to knock and announce themselves and their purpose and give you time to come to the door. The principle behind this is always that even for serious crimes, the people inside the house should be given the opportunity to let the government in peacefully to avoid violence to their body and destruction of their property. This goes back centuries, as I said. There are British common law decisions where, even in cases where, there was one particular case that I think resonates today where a sheriff had come to serve a warrant for a suspected murder, broke into the house, the homeowner shot and killed him. This is in the 1700s. And the British courts let the guy off because they said that the sheriff did not knock and announce himself. The person inside the house could have thought that the sheriff was there to do him harm. There's also, of course, the problem of innocent people in the house who could be affected by a forced entry. And so the Castle Doctrine has long imposed this burden on the government that they have to announce themselves, they have to announce their purpose, they have to give the suspects that they're after the opportunity to avoid violence and destruction. So this tradition carried over to the U.S., and I argued in my book that it's one of the reasons for the Fourth Amendment. I think it's also was one of the justifications for the Second Amendment, and even possibly the Third. I'll let you read the book to get into that discussion. But the first case, I think, that really, in the modern era, that we start to see the Castle Doctrine come into play is Miller versus U.S. This was in the late 1960s. This was a case where the Castle Doctrine was upheld. It's really one of the last cases where it was held in a significant way. In this case, the police had come to into this guy's house. He was suspected of various drug crimes. He opened the door, saw they were police, closed the door. They actually broke the door open, came inside, found a bunch of drugs, and arrested him. He challenged the search in court. The U.S. Supreme Court actually overturned his conviction and imposed the exclusionary rule and said that in a particular case, the police had violated his right and had violated the Castle Doctrine. What's interesting is William Brennan writes the majority decision in this case. What's interesting is he really sort of articulates the reason why we have the Castle Doctrine. He says the requirement of prior notice of authority and purpose before forcing entry into a home is deeply rooted in our heritage. It should not be given grudging application. Unfortunately, just a few years later, we get Kerr versus the United States. In this case, the Supreme Court refuses to uphold the Castle Doctrine. And in this case, there was a forced entry again into a guy's home. Actually, the police got a key from a landlord and just sort of let themselves into the house. But the court actually upholds the search and upholds the conviction. And the reason they uphold it are these exigent circumstances that they say provide exceptions to the knock-and-announce requirement. I think it's important to sort of go into these because these exigent circumstances are cited over and over again in these cases today. And Brennan, in his dissent in this case, articulately lays out why they really shouldn't apply. First of all, Brennan finds no history in U.S. common law, in British common law, or in the U.S. Code for the use of these exigent circumstances. In the circumstances, there are basically two primary ones that are used. The first is that the police should be able to break into your house without announcing themselves if they can argue convincingly that if they announce themselves, you will have time to dispose of the evidence. The other is that if they can argue convincingly, they should be able to break in if announcing themselves will give you time to basically get a gun and shoot them, or if there's reason to believe that you would do that if they announce themselves. Brennan points out that both of these are mistaken for a lot of reasons. First is that they both assume that the suspect is guilty, right? So if the idea is that you're going to dispose of the evidence before the police get in if they announce themselves, the assumption behind that argument is that A, the suspect is already guilty and has drugs in the house, and B, that the suspect will try to destroy those drugs before you can get in. And Brennan says this sort of turns the presumption of innocence on its head. It's the same argument with the second exigent circumstance, which is that the person might be a danger to shoot at or kill the police. Again, you're assuming the person is guilty, and you're assuming that the sort of person who might kill the police. In this particular case, there was actually no evidence presented that Kerr was trying to destroy evidence or was trying to obtain a weapon. Instead, all the police said was that they heard noises inside the house that sounded like people moving around, and they wanted to get in before whoever was inside might have destroyed evidence or gotten a gun. And as Brennan points out, this is absurd, right? Moving around in your house, causing noises in your house is not criminal activity. And in fact, if the police had went to a judge and asked for a search warrant based on the fact that they heard you moving around in your house, the judge would laugh them out of the court. But they can use this evidence to break into your house once they have a search warrant. And Brennan again points out that this is, again, assuming that the person is guilty, and it turns the presumption of innocence upside down. The other problem with the destruction of evidence rule is that, particularly in narcotics cases, it's a rule that's broad enough, and it's an exception, I guess, that's broad enough to swallow up the rule. Basically, if your argument is that the police should be able to break in without announcing themselves if they can show that the person inside might be able to dispose of drug evidence, it basically says that anyone that has a small supply of drugs in their house and a toilet would justify police breaking in without announcing themselves and effecting a no-knock raid. And if you think about it, it's even more absurd than that, right? If you have a small amount of drugs, those can quickly be disposed of. A large amount of drugs, let's say you have several bricks of marijuana or cocaine or heroin, that's going to be more difficult for you to dispose of quickly. So this particular exception actually gives more protection to people who are small-time offenders than people who are big-time drug offenders, or even someone who has committed something more violent than a drug crime. For example, it's very difficult to flush a body down the toilet before the police can get in. Right? Brennan also points out some possible consequences of the decision, which I think are very prescient. He says innocent citizens should not suffer the shock, fright, embarrassment intended upon an unannounced police intrusion. Pointed out that these kinds of raids, taking people by surprise, are going to lead to mistakes, both by police and people inside the houses. It's going to lead to people getting killed. And all this over basically a drug arrest or to prevent people from getting high. And he sadly proved to be very prescient in this, as we'll find out in a moment, which I'll get to later on in the talk. We don't really see a lot of Castle Doctrine cases again until the 1980s, but I'm going to run down a few of them that we do get in the 1980s as the drug war really starts to ramp up. We get Massachusetts versus Shepard. In this case, the majority, again, declines to apply the exclusionary rule. In this case, the police knowingly provided a defective warrant to a magistrate. The magistrate signed the warrant. The police then relied on that defective warrant to break into this person's house. The Supreme Court ruled that the warrant itself may have been defective, but that once the magistrate had signed it, the police were relying on the magistrate giving his okay to the warrant. Therefore, there was nothing wrong with the warrant in terms of applying the exclusionary rule. It's a bit of absurd circular reasoning, but the court, that's the route that the court chose to take. Segura versus the United States. The court ruled that the police who break into a residence without a warrant and then hung out inside the house for 19 hours until they were able to secure a search warrant also didn't violate the defendant's Fourth Amendment rights because the search, for legal purposes, didn't actually begin until they got the search warrant. It didn't begin when they broke into the house and decided to just sort of hang out there for a while. And Oliver versus the U.S. in 1984, we get the Open Fields Doctrine. And here the Supreme Court says that the Fourth Amendment doesn't apply to any open property behind your house. So it applies to your house itself, and maybe to some buildings around your house, but if you have fields, the government is free to sort of swoop over the fields with helicopters at frightening low altitudes in order to look for marijuana plants that you might be growing in those fields. This gets applied in a particular extreme way in 1989 to Florida versus Radley. In this case, the government, without a warrant, actually used helicopters, brought them to dangerously low levels so that they could peer into the windows of this particular property. And the Supreme Court said that this, too, was not a violation of the Fourth Amendment. This one was so absurd that Brennan, he's sort of, at this point, he's toward the end of his career, he's just sort of giving up. At the end of this particular dissent, he's so angry, he just quotes from Orwell's 1984. So, moving ahead to Castle Doctrine cases, in 1995, we get Wilson versus Arkansas. This is the case where the Supreme Court, for the first time, says that the knock and announce requirement is part of the Fourth Amendment, that it's sort of part of the tapestry, as Thomas argues, of the Fourth Amendment. The problem is, Thomas also recognizes these exigent circumstances, and they're sort of described in a way that's so broad, again, that it basically renders the knock and announce requirement obsolete. They don't specifically say what the exigent circumstances are. Thomas just sort of says that they exist. In 1997, 2 years later, Richard versus Wisconsin, we get, so Wilson versus Arkansas was sort of a win for knock and announce in the Castle Doctrine. It was a very sort of Pyrrhic victory because at the same time they point to these exigent circumstances. 2 years later, we get Richard versus Wisconsin, which is another theoretic win. Wisconsin, in response to the Wilson case, passed a law that basically said for any narcotics case, the police are allowed to use a no-knock warrant. Again, citing this destruction of evidence exception. Supreme Court strikes down this. It says you can't just have a blanket exception for any narcotics case. But the opinion is written so narrowly that, it says basically that, I'll just quote you from the majority. For example, a search conducted at a time when only the individuals present in the residence have no connection with drug activity and thus will be unlikely to threaten officers or destroy evidence. So basically they're saying one example of when this blanket exception shouldn't apply is if you're raiding a house where you know there are drugs, but you also know that the person responsible for those drugs isn't there, but there are innocent people in the house who might be, right? So basically the court is saying you can't have a blanket exception, but you know the cases it illustrates to argue that point are such a narrow series class of drug cases that again it's a victory that's sort of hollow in the end. They also say that even if a magistrate denies the police a no-knock warrant when they apply for one, when they get a search warrant, the police can still change their mind when they get to the scene and decide that these exigent circumstances actually do exist, and the court should give them great deference to the police decision once they arrive at the scene. So even if you come to the judge and say, here's why we deserve a no-knock warrant, and the judge says, no, you haven't given me nearly enough evidence, the court's saying that the police, in theory, can still change their mind when they get to the scene and sort of overrule the judge, and the amount of scrutiny the judge should apply to that decision after the fact should be very deferential to the police decision. So in 2003 then, I think we really get the end of the Castle Doctrine. It's a case called U.S. versus Banks, and it was kind of overlooked at the time. Basically, this was a guy, Banks, was taking a shower when the police came to serve this warrant. They knocked and announced. They waited, I think it was 15 or 18 seconds. He didn't get to the door in time. They broke down the door, found drugs. He sued, saying that this was a violation of the knock and announce rule. The Supreme Court upheld his conviction, but what's really sort of disturbing is the way they upheld it. It was a unanimous decision, and Justice Souter wrote the opinion for the court. And basically, the way Souter comes to this, approaches this case is he determines the amount of time that police have to wait before they come in, not by the amount of time it would take an innocent homeowner to get to the door to let the police in and avoid violence and destruction, but by the amount of time it would take a guilty homeowner to destroy narcotics before the police can get in. So we've gone from basically the Castle Doctrine being a way of protecting innocent people from unnecessary violence and destruction of their property, to assuming that everybody who is the subject of one of these drug raids is guilty, and we're going to determine the time that police have to wait, not by how long it takes you to avoid that violence and destruction, but by how long it would take you to destroy evidence, assuming that you were guilty. This is a sort of dramatic turn in the way the court looks at these cases. Finally, we get Hudson versus Michigan in 2006, and this one just sort of does away with the Castle Doctrine altogether. The court says in this particular case that yes, the police violated the knock and announce rule. Yes, they broke in way before they should have. Yes, this guy's rights were violated. But we're not going to apply the exclusionary rule. The evidence can still be used against them. And this basically removes any deterrent whatsoever from police for observing the knock and announce rule. Interestingly, Justice Scalia wrote the majority in this case, and he basically said, he cited a criminologist named Sam Walker, who'd done a lot of research on police discipline and internal police disciplinary procedures. And basically, Walker had concluded that police become much more professional over the years, and they're better at disciplining themselves within the department. But Walker argued that this was because of Supreme Court decisions that had forced police departments to do this. And Scalia actually cites Walker in his opinion, saying, well, we don't need the exclusionary rule anymore, because police are very good at disciplining themselves. Walker wakes up and reads that Scalia has cited his opinion, his work in his opinion, and he was mortified, because this is not what he intended at all. In fact, he then wrote an op-ed in the LA Times where he says, quote, Scalia's opinion suggests that the results I highlighted have sufficiently removed the need for an exclusionary rule. I have never said or suggested any such thing. To the contrary, I've argued that the results reinforce the Supreme Court's continuing importance in defining constitutional protections for individual rights. So basically, Scalia's argument revolved around this work of this academic who says that his work was completely misinterpreted. Of course, there's no sort of do-over. You can't go back and say, Scalia, you need to rewrite this paper because you improperly cited your source. The problem here, then, is we get to this point where there's no sort of oversight whatsoever going on in these particular cases. In 1999, Joseph McNamara, who was the former police chief in San Jose, was a fellow at the Hoover Institution, still is at Stanford, and he had a conference on the drug war in general, but he had a particular panel on these home invasion raids and no-knock warrants. And on the panel, you had a police chief, a mayor, a district attorney, a judge, and some sort of local community activists. But he posed a hypothetical to them. He said, let's say you're we posed it to the police chief, actually. He said, you find out that there's a large supply of, say, marijuana in this particular building. You know your officers, it's a non-violent crime, there's no indication that this person is violent. You know your officers shoot bullets that can go through walls. How do you serve this warrant? And he said, of course, we send the SWAT team in, full bore, no-knock raid. He then looked at the mayor and he said, well, actually, he then walks him down. He says, well, let's say it's not marijuana, let's say it's, counterfeit alcohol, black market alcohol, to still do the SWAT team. Let's say it's counterfeit DVDs, to still use the SWAT team. It's all the way down to, very low-level sort of offenses. Every time it's the SWAT team. He then goes to the mayor and he says, well, do you think this is appropriate? And the mayor said, it's not my job to second-guess the police. Police chief himself, by the way, said he would defer, he would support a SWAT team, but he would also defer to the officers who were conducting the investigation. Went to the DA, she also said, it's not my job to second-guess the police. Went to the judge, who would have signed off on the warrant in theory, said, would you question the amount of force that the police used to serve this warrant? Judge said, no, it's not my job to second-guess the police. So the mayor, McNamara concludes, and I'll just quote what he told me in an interview. He said, the mayor said she knew nothing about these raids and didn't want to know anything until they were over. The judge wasn't interested in scrutinizing the raid until it was over, when any damage would already be done. Everyone said it wasn't their job to worry about it. And so you end up with this dangerous decision that gets made by people of lower rank with little training and little incentive to care about constitutional rights. No oversights, no checks or balances, collateral damage is just part of the game. I want to jump just real quickly to assaults on, securing the border. I had a couple other categories, I think I don't have time to get to them all. But another sort of significant erosion we're seeing in the Fourth Amendment is border searches, and searches at customs stations in airports across the country. And one of the sort of more disturbing decisions we see from the Supreme Court in this area is in 1985, which is U.S. versus Montoya v. Hernandez. This is a woman who was suspected of being a drug mule, swallowing heroin balloons. She was detained at the border, held incommunicado. There was no warrant. They basically put her in a room in front of two customs agents and held her for over 24 hours until she defecated in front of them. She was smuggling balloons, which came out in that process. But she sued and said that this was a violation of the Fourth Amendment rights. The U.S. Supreme Court upheld her detention. Family was not notified. She was basically taken into this back room and held there for 24 hours. Brennan, again, issues this blistering dissent. This is indefinite, involuntary, incommunicado detentions for investigation of a hallmark of a police state, not a free society. In fact, studies at the time shown that 80 to 85% of women who had similarly been detained on suspicion of being drug mules turned out to be innocent. So only about 2 out of every 10 people who customs agents were detaining and holding in rooms until they defecated were actually guilty. This was upheld by the Supreme Court. We've seen this in all sorts of other airport cases. The drug war has become so sort of overwhelming that the court has carved out what a lot of constitutional scholars have called the drug war exception to the Fourth Amendment. Federal courts have upheld detention of people at airports for being the first person off of a plane because you're eager to sort of get out of the plane and get into the country with your drugs. They've also upheld detention of people who were the last person off the plane. So apparently you were waiting until everyone else had gone off to avoid detection. They've also upheld detention of people who conspicuously were trying to be in the middle of the people exiting the plane. They've upheld people being detained for buying one-way tickets. They've also held people from had people being detained just for really flying in from cities known for being hubs of drug importation. As you can tell, the courts have basically said when it comes to borders, there is no Fourth Amendment. Checkpoints. We've seen these, you've probably seen the videos of people who have been avoiding these checkpoints across the country. The Supreme Court has said that the police can't stop you within 100 miles of the border, search your car, basically in order to protect the government's ability to police us for illegal immigrants and illegal importation of drugs. The ACLU actually looked at a map and drew a 100-mile border around or 100-mile line around the U.S. That was 100 miles from the border. Basically, they found that about 190 million U.S. citizens live in what you might call a Fourth Amendment-free zone, where your car can be stopped at any time by police and searched simply because you're sort of in the general vicinity of the border. As you might have seen, there were several court cases recently that said they're coming in from another country and they're in an airport in the U.S. The government can seize your laptop, your phone, any other electronic devices they have based only on reasonable suspicion. They can do it without a warrant. They can hold those items for up to 6, in some cases 6 or 7 months before they're returned to you. They can search them. They can copy, mirror your hard drives, and you really have no recourse. So we have sort of entered this age, and there are several other sort of areas I can get into, but where the government has sort of eroded the Fourth Amendment to the fact that it's basically meaningless at this point. How do we fight this? How do we go back? There are sort of big strategies that we could adopt, including things like trying to get a better lineup on the Supreme Court, limiting qualified immunity for police officers, and so forth. These are all sort of difficult and probably not achievable. The smaller solutions, I think, are better. I think as libertarians, we need to be better at playing offense. We play defense too often. So things like getting involved in sheriff's elections, making appointment of police chief and issue in mayoral elections, asking mayors, what sort of police chief are you looking for? Putting political pressure on police chiefs and sheriffs to make the right decisions about these kinds of cases. Getting involved in judicial elections, which happen across the country and very few people tend to be interested in. Also, district attorney elections. But also, I think in terms of offense, we need to take advantage of high-profile outrages. A lot of you probably saw the case in New Mexico where the guy was pulled over for a rolling stop at a stop sign, and based only on suspicion, the police subjected him to several anal cavity searches, followed by several forced enemas, followed by forced colonoscopy. They didn't find any drugs. But that case was settled. We settled very quickly. The city and the state realized that they made a huge mistake. They gave him a $1.5 million settlement, but then the issue sort of went away. I think it would be important to take advantage of an outrage like that when the entire country is sort of angry about what happened, and to push for legislation, to push for restrictions, and to push back on the immunity police officers get. I actually talked to some constitutional experts about that case. They said that it was certainly a violation of this guy's constitutional rights. I talked to some medical experts who said the medical personnel who conducted these procedures on the guy almost certainly violated their medical ethics. The problem is that both all the law enforcement officers and the medical personnel were unlikely to face any sort of sanction or penalty whatsoever. Why? Well, because the police got a judge to sign off on a warrant, which they were relying upon. That indemnifies them from any sort of civil damages. And the medical professionals were relying on the police. When the police officer comes in the hospital and says, you need to do this, most medical professionals are not going to stand up to the police and say, no, I refuse, although it has happened in some cases. I'll just end with a quote that the title of this lecture is from. It's from Felix Frankfurter and Davis versus the U.S. Case in the 1940s. Frankfurter was one of the sort of original Brennans, I guess, one of the originals for the defenders of the Fourth Amendment. In this particular case, I just want to read the quote in its entirety. It says, "We are in danger of forgetting the Bill of Rights reflects experience with police excesses. It's not only under Nazi rule that police excesses are inimical to freedom. It's easy to make light of the insistence of scrupulous regard for the safeguards of civil liberties when they're invoked on the behalf of people who are unworthy. It is too easy. History bears testimony that by such regard are the rights of liberty extinguished, heedlessly at first, then stealthily, and then brazenly in the end." Do we have time to take questions, or no? All right. Well, thank you for inviting me to talk, and I'd be happy to take questions afterward. And also, we'll be selling books, I guess, right outside the lecture room. So thank you.